Hello, everyone. So, I'm going to be arguing that states should surrender their national sovereignty and comply to humanitarian international law. Um, First, I just wanted to explicitly talk about, okay, what exactly is humanitarian international law? For the sake of understanding my argument. So, humanitarian international law is, as said by the ICRC, or International Committee of the Red Cross, a set of rules which seek to limit the effects of armed conflict. So, in the international community, humanitarian law are the laws and agreements that are made to regulate war and effects of war. And then a humanitarian approach of this would be using international law to maximize the well-being of people in the event of war or other armed conflict. So that being said, some of the reasons I believe that states should surrender their national sovereignty is, for one, all countries in the world, save two, which I'll talk about in a minute, already are part of the United Nations, which of course is probably the most prominent international body, international legislative body with judicial power. And member nations already relinquish national sovereignty to some extent. And by joining the United Nations, they do agree to comply with humanitarian law. Some of the obligations that the UN Charter delineates are maintaining international peace and security, developing friendly relations among nations based on respect for the principle of equal rights, and taking other appropriate measures to strengthen universal peace. So fundamentally, the United Nations is a humanitarian organization according to its structure and its charter, disregarding how it actually has acted on the international stage, but focusing on what you need to be a member nation. It technically is a humanitarian international organization complying with humanitarian law. So back to the point of the two states that are not part of the UN, the only ones are Palestine and the Holy See, or the Vatican City, due to their status of statehood being disputed. But they're both of these states are still invited to the UN and can participate in the General Assembly. So they do participate in the United Nations, and they do relinquish what sovereignty they do have to some extent. And complying with the UN is in their interest in order to gain statehood, because although there's no specific way to gain statehood officially, being recognized by the international community is essentially how you become a state, and therefore participating in the United Nations is in their best interest. So all countries in the world already relinquish some of their national sovereignty, not all of it, but enough that they are technically required to comply with humanitarian law. Obviously, we know that's not the way it always plays out. However, technically speaking, all member nations of the United Nations are required to comply with humanitarian efforts, which, because it has a judicial, not branch, but judicial organization, I guess, the ICJ, they are expected to comply with that. And then another reason beyond the whole duty to the UN, I think that states should relinquish some of their sovereignty, is that international law, despite having no official law enforcement, does have the power to identify humanitarian crises and recognize a perpetrator, which can be very politically damning, despite the fact that they don't have the power to go send troops and arrest people who are committing humanitarian crimes or crimes against humanity, the implications of an ICJ ruling can be very detrimental to a country. And although the ICJ or the ICC or another international criminal court may not be able to effectively prosecute the offender, depending on their status in world hegemony, the political repercussions of this are going to be quite detrimental to the country. So following the treat others as you want to be treated mindset is in the interest of states in order to maintain support and security in case a humanitarian crisis on their front occurs. So back to the ICJ thing. The ICJ, because it doesn't have an official law enforcement, it can't technically enforce its rulings. And as we saw earlier in this course with the U.S. Nicaragua case and similar cases where a dominant hegemonic power will be a part of a case and then just ignore the ruling. Obviously that's possible, but for smaller states who do rely on those cases, it is in their best interest to comply with that. So beyond the duty to complying for the sake of if a humanitarian crisis were to happen in your own country, another thing I'd like to point out is I do not agree with relinquishing complete sovereignty. I mean, I'm not saying that states should completely relinquish their sovereignty for the sake of humanitarian law and just creating an international superpower law system or whatever. However, the amount, that's not a very good word to use for it, but the amount of sovereignty relinquished in the pursuit of humanitarian law is really no different than what we relinquished to the United Nations. Considering, if we think about humanitarian law and law being prosecuted on the international stage, it's going to be from the ICJ, ICC, or similar court. And for the ICJ, that's a part of the United Nations, and your states already relinquish some amount of sovereignty to become a member nation to the UN. So the amount of sovereignty relinquished is not going to be any different. Complying by humanitarian law simply means abiding by whatever agreements are made by the international community regarding armed conflict. For an example, one of the most prominent agreements came from the Geneva Conventions, which wasn't a part of the United Nations. Obviously, for non-state actors, this doesn't really apply. It's much more complex than just national sovereignty, since they don't have their own nation, non-state. But speaking specifically to states, national governments who participate in the United Nations and international law, which all of them do, it is in their best interest to comply with humanitarian law, and they should relinquish a little bit of sovereignty for the sake of complying with humanitarian law.